every crime is a wound on the world. We're here to dissect it, layer by layer, to find the truth buried within. This is Anatomy of Crime. In February of 2020, a sound rippled out from a Manhattan courthouse, a sound of collective, shuddering relief. It was the sound of a verdict. After years of whispers, decades of fear, and a shattering cultural excavation that began in 2017, Harvey Weinstein, the titan, the mogul, the monster, was found guilty. He was convicted of a first-degree criminal sexual act and third-degree rape for the dozens, perhaps hundreds of women who had carried the secret of his abuse. It was more than just a legal finding. It was a validation. It was the closing of a dark chapter, the moment the monolith of power finally, decisively, cracked. The king, clad in an ill-fitting suit and clutching a walker, had been dethroned. The 23-year sentence that followed felt like a firewall, a promise that the era of open secrets and weaponized power was truly over. Then, on April 25, 2024, the ground fell away. The New York Court of Appeals, the state's highest court, did the unthinkable. In a stunning 4-3 decision, it vacated the conviction. It erased the verdict. It ruled that the 2020 trial, the one celebrated as a watershed moment for justice, was egregious and prejudicial. The very foundation upon which the conviction was built, the testimony of other women, the evidence of a pattern of abuse, was declared fundamentally unfair. The case was sent back for a retrial, a do-over, wiping the slate clean. And when that retrial convened in 2025, the outcome was profoundly different. A fractured, messy verdict that reflected the very legal limitations the first trial had tried to overcome. Today, we are not here to simply recount the sins of Harvey Weinstein. The world knows what he did. Instead, we are here to dissect the anatomy of a legal earthquake. We will explore how a conviction celebrated as a cultural watershed was built on a legal foundation so flawed it crumbled on appeal. We will examine the careers he built and the lives he destroyed, the system of silence that protected him, and the precise legal arguments that brought him down, only to see him handed a stunning reprieve. This is a story about the profound, agonizing gap between what we know to be true and what the law will allow us to prove. We are exploring the anatomy of power and procedure, and the search for justice when a predator's crimes are a pattern in a legal system designed to judge only a single act. To understand the earthquake, you must first understand the mountain that fell. Harvey Weinstein was not merely a movie producer. He and his brother Bob were architects of modern independent film. From their origins in Queens, New York, they built an empire, first with Miramax Films and later with the Weinstein Company. Their names became synonymous with a specific kind of cinema, edgy, smart, and above all, prestigious. They were the star makers, the kingmakers, the masters of the Academy Awards. Films like Pulp Fiction, The English Patient, Good Will Hunting, and Shakespeare in Love didn't just win Oscars. They redefined the industry. Harvey, in particular, was the face of this empire. He was a brute force of nature, a renowned intellect, a bully, and a savant. His nickname was Harvey Scissorhands for his ruthless habit of re-editing films against directors' wishes. He was loud, profane, and terrifying. He cultivated an image of a man who would move heaven and earth for a film he believed in, and who would destroy anyone who got in his way. This public persona, that of a volatile but brilliant tyrant, was in itself a form of camouflage. It normalized his aggression. It made his temper a part of his brand. But behind the closed doors of luxury hotel rooms, suites, and offices from Cannes to Los Angeles, this aggression had a far darker, criminal expression. For nearly 30 years, Harvey Weinstein operated with impunity. The stories were whispered, a corrosive open secret known by agents, assistants, journalists, and actors. The pattern, as it would later be alleged by over 80 women, was nauseatingly consistent. It began with a professional pretense, a meeting to discuss a script, a role, or a career trajectory. Weinstein was the man who held the keys to the kingdom, and an audience with him was an opportunity no aspiring artist could refuse. The meeting would be moved, often at the last minute, to his hotel room. Once there, the dynamic would shift. He would appear in a bathrobe or naked. He would request a massage. He would masturbate. He would promise career-making roles in exchange for sexual acts, or he would threaten career-ending blacklisting for refusal, and in many alleged cases he would overpower, assault, and rape. This was not a series of isolated incidents. It was a system. It was a conveyor belt of abuse, protected by a fortress of power. His victims were almost always young, ambitious women dependent on his goodwill. He was their boss, their mentor, their potential discoverer. He preyed on the power imbalance with surgical precision. The system was reinforced by a phalanx of enablers. Assistants were tasked with procuring the women and managing the meetings. Agents and managers, hearing the whispers, allegedly told their clients to be careful or to simply endure it as the cost of doing business. Lawyers were on retainer to draft ironclad non-disclosure agreements, buying silence from those who dared to complain. He reportedly used his leverage with media outlets to kill negative stories, and he allegedly hired private investigators, including the firm Black Cube, staffed by ex-Mossad agents, to dig up dirt on his accusers and the journalists investigating them. For decades, this system held. Women who spoke out like Rose McGowan or Rosanna Arquette found their careers mysteriously stalled. Others, like Gwyneth Paltrow or Angelina Jolie, had encounters with him early in their careers, managed to escape and warned others, but the machine churned on. The sheer scale of his power created a gravitational pull. To defy him was to risk being ejected from the industry entirely. He was too big to fail, too powerful to challenge. The whispers remained whispers, the secrets remained secret, until they didn't. The dam broke on October 5, 2017. A meticulously reported article by Jodi Kantor and Megan Tuay was published in the New York Times. It detailed, for the first time on the record, decades of allegations and financial settlements. 5 days later, Ronan Farrow, in The New Yorker, published his own explosive investigation, which included more harrowing accounts of assault and rape, including a recording of Weinstein admitting to groping a model. The combined impact of these stories was not just a news cycle, it was a detonation. The whispers became a roar. Within days, Harvey Weinstein was fired from his own company. He was expelled from the Academy of Motion Picture Arts and Sciences. He became a global pariah. But more than that, his fall triggered a cultural movement. The hashtag #MeToo, created years earlier by activist Tarana Burke, was amplified by actress Alyssa Milano in the wake of the Weinstein story. It became a global rallying cry. Millions of women began sharing their own stories of harassment, abuse, and assault, exposing the rot, not just in Hollywood, in but every industry, in every corner of society. The fall of Harvey Weinstein was not just the fall of one man. It was the beginning of a massive, painful, and necessary reckoning. But a cultural reckoning is not a criminal conviction. As the #MeToo movement raged, the legal system began its slow, methodical work. While Weinstein faced allegations across the globe, the first criminal charges to stick came from the Manhattan District Attorney's Office. In May 2018, he was arrested and charged. The case that would go to trial in 2020 was not a sprawling indictment covering all his alleged victims. The law doesn't work that way. The prosecution had to build a case around specific chargeable offenses that fell within the statute of limitations. The indictment centered on the testimony of two women, Miriam Haley, then known publicly as Mimi Halei, and Jessica Mann. Miriam Haley was a former production assistant at the Weinstein Company. She alleged that in 2006, Weinstein had lured her to his Soho apartment, held her down, and forcibly performed oral sex on her. Her testimony was a harrowing account of a young woman trying to navigate the professional demands of a powerful boss, only to find herself in a terrifying, non-consensual situation. Jessica Mann was an aspiring actress who had a complex, multi-year relationship with Weinstein, one she described as deeply manipulative and often non-consensual, culminating in a violent rape in a Manhattan hotel room in 2013. The prosecution, led by Assistant District Attorney Joan Illusiorbone, knew they faced an uphill battle. The defense, led by the formidable Donna Rotunno, was already telegraphing its strategy. This was not rape, it was transactional sex. They would argue that these women were consenting adults who had engaged in a relationship with Weinstein to advance their careers, and were now reframing that relationship as abuse in the harsh light of the #MeToo movement. Rotunno's team planned to use friendly emails, text messages, and evidence of continued contact between the women and Weinstein after the alleged assaults to prove consent, or at least to create reasonable doubt. The prosecution's challenge was to provide a context for the jury. How could they explain why a woman might stay in contact with her abuser? How could they demonstrate the immense coercive power Weinstein wielded, which blurred the lines of consent and made "no" a career-ending word? Their answer, and the legal maneuver that would become the case's fatal flaw, lay in a New York-specific rule of evidence known as the Molyneux Rule. The Molyneux Rule is named after a 1901 case. In essence, it governs when a prosecutor can introduce evidence of a defendant's prior bad acts or uncharged crimes. The core principle of American justice is that you are tried for the crime you are charged with, and only that crime. A jury is not supposed to hear that you robbed a bank 5 years ago when you're on trial for a different robbery today. That would be propensity evidence, evidence that just shows you have a propensity to rob banks, which could prejudice the jury against you, regardless of the evidence for the current charge. The Molyneux Rule, however, carves out specific exceptions. Prosecutors can introduce prior bad acts, not to show propensity, but to establish a motive, intent, absence of mistake or accident, a common scheme or plan, or the identity of the perpetrator. The prosecution filed a motion to have dozens of other Weinstein accusers testify. They argued this was not propensity evidence. They argued it was necessary to show Weinstein's common scheme or plan: the hotel rooms, the career promises, the isolation, the abuse of power. They argued it was necessary to show his intent, that these were not misunderstandings, but a deliberate, repeated pattern of predation. And they argued it was vital to explain the absence of mistake, that he knew exactly what he was doing. Judge James Burke, who presided over the trial, had to weigh this. He had to balance the prosecution's need to tell a complete story against Weinstein's fundamental right to a fair trial on the charges at hand. In a crucial pretrial decision, Judge Burke struck a compromise. He denied the prosecution's request to call dozens of women, but he granted permission for 3. First was Annabella Sciorra, the Sopranos actress, who testified that Weinstein had violently raped her in her own apartment in the early 1990s. Her testimony was also used to support a more serious charge of predatory sexual assault, which required proving a pattern of serious sex crimes against multiple victims. The other two Molyneux witnesses were Terrell Wolfe, an aspiring actress, and Dawn Dunning, who had worked in his company. Both told stories that mirrored Haley's and Mann's: the luring, the hotel rooms, the explicit quid pro quo of sex for career advancement. The defense, led by Rotuno, objected strenuously. They argued this was propensity evidence, plain and simple. They argued that by allowing these women to testify, the judge was essentially telling the jury, this man is a monster who did this to 3 other women, so he must have done it to Miriam Haley and Jessica Mann. They argued it made a fair trial impossible. Judge Burke disagreed. He ruled that the testimony was admissible under the Molyneux exceptions and that he would provide a limiting instruction to the jury, ordering them to consider this testimony only as it related to Weinstein's state of mind and common plan, not as proof of his character or propensity. The trial, which began in January 2020, was a media circus. Weinstein arrived each day looking frail, using a walker, a stark contrast to the imposing bully described on the stand. The testimony was brutal. Miriam Haley and Jessica Mann were subjected to days of punishing cross-examination. Rotuno and her team picked apart their stories, highlighting every friendly email, every subsequent meeting, every inconsistency in their memories. They painted the women as opportunists who had willingly engaged with Weinstein and were now, as Rotuno infamously said, experiencing buyer's remorse. The Molyneux witnesses, however, changed the atmosphere in the courtroom. Annabella Shora's testimony was powerful and chilling. Dawn Dunning and Terrell Wolfe provided the critical context the prosecution needed. Their stories built a bridge for the jury, allowing them to see the allegations against Haley and Mann not as isolated incidents, but as data points in a 3-decade pattern. The prosecution argued that this pattern was Weinstein's signature, his modus operandi. It explained why Haley and Mann might have frozen, or why Mann might have maintained contact. This was, they argued, the anatomy of his control. On February 24, 2020, after 5 days of tense deliberations, the jury delivered its verdict. They acquitted Weinstein on the 2 most serious charges: predatory sexual assault, which had been based on Shora's testimony, and first-degree rape related to Jessica Mann. But they found him guilty of a first-degree criminal sexual act against Miriam Haley and third-degree rape against Jessica Mann. It was a split, nuanced verdict, but it was a conviction nonetheless. Justice, it seemed, had been served. In March, Judge Burke sentenced him to 23 years in prison. A few months later, Weinstein was extradited to California to face separate charges, where he would eventually be tried and convicted, receiving another 16-year sentence. The New York conviction, the first domino, felt secure. But the defense's objections had not disappeared. They had been preserved for appeal, and for 4 years while Weinstein sat in prison, the case worked its way through the New York appellate system. The defense's argument remained the same. The Molyneux witnesses and another, separate error by Judge Burke had irrevocably tainted the trial. That second error, they argued, was just as critical. Judge Burke had ruled that if Weinstein chose to testify in his own defense, prosecutors would be allowed to cross-examine him not just about the charged crimes, but about a vast array of other bad acts, including his famously volatile temper, his habit of throwing objects at assistants, and his verbal abuse of colleagues. The defense argued this Sandoval ruling, another New York-specific evidence rule, was massively prejudicial and effectively chilled Weinstein's constitutional right to testify on his own behalf. He couldn't take the stand to deny the rape allegations without being forced to defend himself against a lifetime of being a bully. On April 25, 2024, the New York Court of Appeals issued its decision. In a 43-majority opinion written by Judge Jenny Rivera, the court agreed with the defense on every major point. The ruling was a stunning rebuke of the 2020 trial. Judge Rivera wrote that the trial court had egregiously erred in admitting the testimony of the Molyneux witnesses. She wrote that this testimony served no material non-propensity purpose and was intended only to establish defendant's propensity for committing the charged offenses. The court found that the common scheme or plan exception did not apply because the alleged acts were too different in time and detail, and there was no evidence they were part of a single, unified conspiracy. The court dismissed the idea that this testimony was needed to explain the intent or state of mind of the defendant, calling that a pretext for what was, in their view, pure and simple character assassination. The majority opinion was a blistering defense of a core legal principle. It is a fundamental principle of our jurisprudence that a defendant may not be convicted of a crime based on evidence of a prior bad act or criminal conduct. The court essentially ruled that the #MeToo movement's desire for a narrative reckoning had improperly superseded Weinstein's right to a fair trial. The ruling stated that the synergistic effect of this improper testimony, combined with the egregious Sandoval ruling that prevented Weinstein from testifying, demanded a new trial. The conviction was vacated. The dissent, written by Judge Madeline Singas, was equally passionate and represented the shock and anger of many. Singas called the majority's decision a distressingly myopic view of the law that ignores the realities of sexual violence. She argued that this was exactly the kind of case the Molyneux rule was designed for. The pattern, she argued, was the evidence. Weinstein's M.O., the use of his power, the isolation of victims, the pretense of a professional meeting, the promises and threats, was a common scheme so clear and so repetitive that it was essential for the jury to hear it. She argued the majority was whitewashing the facts and creating a dangerous precedent that would make it immeasurably more difficult to prosecute serial sexual predators whose entire method of operation is built on a pattern. The 43 split in the state's highest court revealed a deep, fundamental fissure in the legal world. How do you handle a pattern of predation without creating a trial based on prejudice? The cultural whiplash was severe. The victory that had been a cornerstone of the #MeToo movement was gone. Miriam Haley and Jessica Mann, who had endured the trauma of a trial and cross-examination, were told they would have to do it all over again if the district attorney chose to retry the case. For many survivors, the ruling felt like a betrayal, a signal that the legal system's arcane rules were more important than the lived reality of victims. But for Weinstein's defense, it was a vindication of the legal principles they had argued from day one. The Manhattan District Attorney, Alvin Bragg, immediately vowed to retry the case. And so, in 2025, the circus began anew, but the landscape was entirely different. The prosecution now had to fight with one hand tied behind its back. Judge Burke's egregious errors would not be repeated. The new judge presiding over the 2025 retrial barred the Molyneux witnesses from testifying. Annabella Shora, Dawn Dunning, and Terrell Wolfe would not be taking the stand. The jury would not hear their stories. The prosecution was also forced to relitigate the charges related to Annabella Shora, which had previously resulted in an acquittal for the predatory charge, but were now being reframed. This time, the prosecution had to build its case only on the words of the three women whose charges were in the indictment. Miriam Haley, Jessica Mann, and Annabella Shora. They could not use the powerful corroborating MO testimony from other victims. They had to present these alleged assaults as isolated incidents, disconnected from the larger narrative that the world already knew. The defense, now supremely confident, doubled down on its original strategy. They attacked the credibility of the women, highlighted the friendly emails, and framed the encounters as transactional and consensual. Without the backdrop of the other Molyneux witnesses, these arguments carried new weight. The jury was now forced to decide the case in a vacuum, exactly as the defense had always wanted, and the Court of Appeals had mandated. The jury's deliberations in 2025 were, predictably, long and fractured. The resulting verdict was a mirror of this new, constrained legal reality. It was a messy, compromised, and deeply unsatisfying outcome for both sides. The jury found Weinstein guilty of sexually assaulting one woman, Miriam Haley. They acquitted him entirely on the charges related to another, Jessica Mann, and on the rape charge involving the third accuser, Annabella Shora. The jury was hopelessly deadlocked. They could not reach a unanimous decision. It was, in many ways, a legal stalemate. The prosecution had secured a conviction, saving the case from total collapse. Miriam Haley's ordeal was, once again, validated by a jury of her peers. But the acquittal of the charges related to Jessica Mann and the hung jury on the Shora charge were seen as major victories for the defense. It proved their central thesis. When you strip away the prejudicial noise of the Molyneux witnesses, the case against Harvey Weinstein was far from a slam dunk. It was a case of he said, she said, complicated by past relationships and blurry lines. And it was not enough to convince 12 jurors unanimously on all counts. And so, where does this leave us? Harvey Weinstein is not a free man. This is perhaps the most critical piece of the entire saga. While his New York legal battle raged, his separate 16-year sentence from his 2022 California conviction for the rape and sexual assault of another woman remains in effect. As of now, that conviction stands. He will remain incarcerated, a frail and ailing man in a prison cell, regardless of the final sentencing in the fractured New York retrial. But the anatomy of this case was never truly about just one man's freedom. It was about the legal system's ability to evolve and confront a specific type of crime, serial sexual predation by the powerful. The 2020 trial was an attempt to stretch the existing rules, to use the Molyneux doctrine to allow a jury to see the full picture, the unmistakable pattern. The 2024 reversal was the legal establishment snapping back, reasserting the primacy of procedure over narrative. The 2025 retrial, with its muddled verdict, showed the consequences of that snapback. It demonstrated that when you force a jury to look at a single puzzle piece, they may never see the monster in the full picture. The case of Harvey Weinstein dissects the painful tension between cultural memory and legal proof. We, as a society, know what he was. Dozens of women, across decades, have told the same story. The open secret is now just an open fact, and yet, the law, in its meticulous and perhaps necessary insistence on fairness, demands that this mountain of truth be set aside. It demands that the accused be judged not on his reputation, not on his pattern, but on the isolated charge before the court. The case of Harvey Weinstein leaves us with this chilling anatomy. A cultural reckoning built on the stories of dozens, but a legal conviction hanging by the thread of what the law would allow a jury to hear, proving that in the cold architecture of the courtroom, the shadow of a pattern is often not enough to convict the man. This has been Anatomy of Crime, where the truth is never simple, but always worth seeking.